Mr. Speaker.
I call Louisa Wall, 5 minutes.
Tēnā koe te māngai o te whare. This is the third reading of the Children, Young Persons and Their Families Advocacy, Workforce and Age Settings Amendment Bill, and Labour is opposing this piece of legislation. However, I do want to highlight that we do support the extension of the statutory age of care and protection to include young people under 18. And that makes sense to us because we're talking about children. I particularly want to acknowledge my colleague Jacinda Ardern, who isn't able to communicate this on her own behalf because she established a petition that asked for that exact legislative reform. And I'd also like to acknowledge LifeWise, Dingwell Trust, Youthline, the Child Poverty Action Group, the Wesley Community Action and Christchurch Methodist Mission, because in fact they wanted the extension of age to 21. And so I do want to highlight that the Minister has signalled that the next step in this process is to enable young people to remain with caregivers up to the age of 21, and also she has highlighted transitional support and advice up to 25 years. So we support that aspect of this piece of legislation. However, Mr. Speaker, the aspect that we don't support is that this bill also contains what we call a massive regression and dangerous set of provisions which will allow the Chief Executive to delegate statutory powers, legislative authority that currently only can be performed by social workers with contracted providers. So the Minister has been really interesting because she talks about this being about a multidisciplinary approach, that there are many professionals involved, that you have to be appropriately qualified, but she actually doesn't list who those appropriately qualified people should be. In fact, what she did do was reference the delegation needs to be supported by contractual obligations. So in fact, what this House wants us to do is to enable the Chief Executive to delegate to any contracted entity the ability to take our children. And actually that's at the heart of our opposition, because central to the functioning of child, youth and family is a social work profession that already is supposed to place at the heart of that practice the best interests of the child. And so what it really does for us is say who should have the power to remove children. Now, from our perspective, it should be only qualified people, and those qualified people have up till today, when this legislation goes through the House, been qualified social workers. But what this piece of legislation does is open it up actually to anybody who's got a contract with child, youth and family. And so we can't support that. I guess in preparing for this speech, what I'm also interested in is if any entity who's got a contract with child, youth and family can take children, I want to know what the requirement is in terms of placing children within either whānau, hapu and iwi. And I want to stress that this particular piece of legislation is hugely relevant for our Indigenous community, that in fact 61% of our children in care are Indigenous children. And the requirement in the current legislation, Mr. Speaker, is that those children in the first instance must be placed within their whānau, but they must be placed within their whānau who have the capacity to care for the children. And if they can't find whānau members, then they're supposed to find hapu members. And then if they can't find hapu members, they're supposed to find iwi members. And the reason that the legislation says that, Mr. Speaker, is because inherent to every child is the right to their whakapapa. It's the right to know who you are and where you come from. And if you're an Indigenous child, who you are and where you come from is based on your pepeha, what your maunga is, what your awa is, who your marae is, and your ability to actually create an identity through actively being engaged in that identity through participation at the marae. And so I want to know actually currently how many children get a cultural assessment, and will these entities be able to undertake a cultural assessment to ensure that our children have, as of right, access to those institutions that help them form a positive identity. And I think at the heart of this piece of legislation actually is going to be more harm to our children, not care and protection as they should have and are entitled to. Thank you, Mr. Speaker.